Well, good afternoon, everyone. Thank you for joining Andrew and I for the latest in our construction winter webinar season. The focus of this webinar is prolongation in consultants' appointments. Prolongation is a thorny issue at present, particularly as projects have been subject to delays during the initial COVID lockdown, as well as delays associated with social distancing and supply chains. In the current hard contractual market, consultants are also facing additional barriers to recovering increased fees following prolongation, and they are increasingly being asked to accept responsibility for project delay. Before we start, some brief introductions. My name is James Vernon, and I'm a partner at Beale & Co in the construction, engineering and infrastructure team, and I specialise in on-project advice and dispute resolution. I'm joined by Andrew Croft, a senior associate in construction, engineering and infrastructure team with me, and he specialises in contractual and on-project advice. For those of you who don't know us, Beale & Co are a specialist law firm. We specialise in domestic and international construction and insurance law, and we have over 50 years providing advice relating to complex projects and disputes. We work with construction professionals, contractors, developers, investors and employers, providing a full project service. We have over 100 lawyers now, and we are spread across 4 offices in London, Bristol, Dublin and the United Arab Emirates. Please do visit our website or contact me or Andrew should you require further information. So as a brief introduction, today's webinar will cover the topics on this slide. We will start with a summary of what prolongation actually is and common issues that arise. We will then look at how prolongation is or is not dealt with in the standard form appointments before covering arguments available to consultants to claim prolongation, subject of course to the applicable contractual terms and conditions, including evidence to support and other practical tips to safeguard against unrecoverable costs due to a project programme extending. During the webinar, we will be using a case study, which we hope can put some of the themes being discussed into context. You can raise questions on the interactive taskbar down the side of your screen. If we don't have time to progress through the questions, we will deal with these after the session by circulating a Q&A summary to all attendees. And this webinar is being recorded, and we will circulate a copy of the slides afterwards, which is usually the first question we get asked. I will now hand you over to Andrew, who will consider what is prolongation.
Many thanks, James. As James mentioned, the thorny issue of prolongation in consultants' appointments is one which we are increasingly being asked to advise on at the moment, and it is often not a straightforward area. So, going back to basics, what is prolongation? As indicated in the Cambridge Dictionary definition on the slide, prolongation means something has taken longer over a period of time. For a more construction-specific definition of prolongation, the Society of Construction Law Delay and Disruption Protocol describes prolongation as an extended duration during which time-related costs occur or are incurred. This still does not completely hit the nail on the head in terms of prolongation under a consultant's appointment. The Delay and Disruption Protocol is very much focused on the approach to delay and disruption to works under the building contract, and not services. So, a more focused definition of prolongation in consultant's appointment is that the services have taken longer than expected. Now, sometimes this may just be a case of the consultant having entered into a bad bargain and/or underestimated the complexity of the task. And that isn't really what we're talking about today by prolongation. A key aspect of prolongation for consultants is that it often occurs due to circumstances outside their control. For example, if the client or other members of the team cause a delay. We will explore this further during the course of the webinar. As we've mentioned, prolongation is an increasingly problematic issue for consultants in the current market. Why is that the case? Firstly, we are seeing more and more consultants impacted by prolongation and then seeking to recover additional fees to reflect additional costs they have incurred. Now, COVID-19 has obviously had a major impact on the number of projects which are delayed, particularly causing delay to the construction phase. In addition, the current contractual market is a very tough one, and so consultants are increasingly being asked to take on the risks of additional costs arising from prolongation, as well as potentially being responsible for failure to comply with the programme as a result of that prolongation. This means that it's not unusual for a consultant to be expected by a client to accept an appointment where there's no entitlement for the consultant to have additional payment as a result of prolongation, and the consultant is also asked to take responsibility for any failure to comply with the programme. One reason prolongation can be a difficult issue for a consultant is that often clients simply do not understand how delays can impact a consultant business. As indicated in the common response on the slide, it's common for clients to simply say, well, if the services haven't changed, you shouldn't be entitled to additional payment. However, whilst prolongation may well mean the consultant is providing the same services over a period of time, the fact that those services have been extended and prolonged means that it's inevitable that additional resources and costs will be needed, and it may be that the consultant has had to remobilise and demobilise over that period, as well as repeat work. In our view, a right to additional payment and an extension of time as a result of prolongation, which is outside the consultant's control, should be a key item on every consultant's contractual shopping list in the current market. To draw out some of the difficulties we are often seeing in relation to prolongation, we thought it would be useful to refer to a case study throughout this webinar. This will provide a practical example of how we're seeing this issue arise. So, here are the facts. ABC Consultant provided a fee proposal which made clear that the services were anticipated to be completed in 13 weeks and highlighted that if there were any delays, the fee may need to be revisited. The client then provided a significant number of comments on ABC's designs, and there were numerous delays due to the planning process and the contractor. The services were, as a result, delayed by 17 weeks, taking in total 30 weeks to complete. ABC then sought to recover the additional week's work based on the weekly rate they had included in the initial pre-proposal. At that point, the client provided the usual response of resisting the entitlement to additional costs on the basis that it did not consider that any additional services have been provided. As I said, we will refer back to this during the course of the webinar and touch upon some of the risks of this sort of situation and some lessons learned. I will now hand you back to James, who will consider the effect that prolongation can have on the services.
Thanks, Andrew. Leaving aside the applicable contractual clauses that may or may not entitle a consultant to costs and or extended programme associated with prolongation, it's always necessary to consider what the impact of the project programme being extended actually has on the consultant. And typically we see three events. Firstly, the consultant provides the same services over a longer period, but no real change in quantity. So for an example, an architect has to produce a workstage D design and has budgeted for that design in the fee based on a period of time to complete that task. If that period of time is extended, but the actual work doesn't change, i.e. it's the same design process being followed with no changes or instructions or comments to deal with, and no need for the consultant to demobilize or remobilize for a significant period, then this is unlikely to be an event that would ordinarily lead to an entitlement to additional money. However, if the reason the extended period for providing that design is not the consultant's responsibility, say for example the client had to resolve a funding issue before continuing the project, then that should be recorded, and if so, an extension to the consultant's programme be agreed, because it may knock on the future stages. So using our case study, this would be the scenario if the client had not made any comments on the design, or if in fact the comments arise from deficiencies in the design and so are necessary to get it to stage D. The second broad type of event is where the same services are provided over a longer period in increased quantity. An example here is a consultant agrees to attend fortnightly progress meetings for the life of the project and includes in the fee allowance for 20 meetings based on a 40-week construction programme. However, for reasons outside the consultant's control, the programme is extended by 20 weeks. Under the terms of that appointment, the consultant has agreed to attend these progress meetings. However, there's no fee allowance for the additional 10. If the conditions are drafted with this in mind, an additional fee could be recoverable for the prolongation effect. It will then turn on what the basis of that additional fee should be. As with the first event, if the reason the extended period is not the consultant's responsibility and impacts on other services, then that should be recorded so that everyone knows the impact on the programme the consultant has to follow. Going back to our case study, this would be attending weekly design team meetings, for example, during the 17-week delay that wasn't allowed for in the original fee. The third type is a consultant providing additional services during a period of prolongation. For example, there can be delays in obtaining planning permission, which takes 4 months instead of the planned 1 month. In that period, the client takes the opportunity to instruct amendments to items of design that had already been approved. Although this instruction could be said to have been caused by the delay period, as if the planning permission had been obtained on time, the project would have been moved on and more likely than not the design fixed, the entitlement to an additional fee rests with whether it can be shown what has been instructed is an additional service, and so a fee under that and not strictly related to prolongation. We think that demonstrating what broad event a claim falls into is key. It forms the basis of the relevant contractual clauses relied on and what evidence would be needed to support the claim. And that does not mean being reactive. Consultants should be proactive in understanding and managing their programme so that relevant notices can be given as soon as an event which is or is likely to prolong the provision of the services arises. Too often we see dates and appointments for completion of services go by, but with no acknowledgement of what that means to the ongoing provision of those services. So, for example, if you are appointed in your role to attend progress meetings and have included a fee allowance for a set number based on the original programme, make sure there is a central record of how many meetings are actually attended and ensure a notice goes in before the 20th is attended so that the entitlement to an additional fee has been made before the 21st is attended if the 20 number is what you've been appointed to attend. Now, it's appreciated that this may lead to some awkward discussions with clients if they consider that it is the consultant who has caused or contributed to the prolongation of the project. But often, as we will go on to discuss, contractual clauses that entitle an additional payment or adjustment to the consultant's programme for delivery contain what are called condition precedents. So a failure to notify in the time period set out, which can be days or as soon as aware or as soon as reasonably practicable, that failure loses an entitlement, and so it may be better to have those conversations rather than lose the right to make a claim. Because if there ends up being 50 meetings, you cannot afford to lose the right to claim for the fee related to attending all those additional meetings. So as mentioned, the contractual terms are key to unlocking any entitlement to additional fees, and an extension to the programme. So I'll now hand you back to Andrew to take you through contractual requirements and the typical contractual position we see.
Thank you, James. So how does prolongation typically fit in with the contractual position? A key difficulty is that prolongation by definition occurs over an extended duration of time, whereas contracts in the current market typically require the consultant to proactively notify and manage delay. It goes without saying that it is important to manage change, and in particular delay, under every contract. There can often be a fear of being too contractual, and that by doing so may offend the client. However, it is very important that if delays occur due to circumstances for which the consultant is not responsible, the consultant draws a line in the sand and provides any required contractual notice. Failure to do so will make it difficult for the consultant to recover any additional fee or to agree an extension to the programme. And as James mentioned, many contracts include a time bar for notifying this. Similarly, it's important that the programme is regularly reviewed and that any events that may delay completion of the services within the original timescale are recorded and dealt with, including those that are identified in the slide, i.e. instructions for additional work, late supply of drawings by other consultants, inefficient working by third parties, or requirement to provide site resource over an extended period. It is easy to be overly focused while you're providing services on specific variations to the services and seeking to recover additional costs, and for the impact on the programme to fall through the net. So consultants do need to make a real effort to stay on top of time as well as money. In that way, in our view, consultants should think more like contractors when they're approaching delay and prolongation. So, going back to the case study, as soon as ABC realised that the 13 weeks was not achievable, or might not be achievable, it should have tried to discuss this with the client and notify the client of the causes of that delay. I will now have a look at the impact of prolongation under a few standard form consultancy appointments. I appreciate that in the current market, it is quite rare for a standard form consultancy appointment to be entered into. However, these provide some useful pointers and tips for how prolongation might be approached contractually. Firstly, the recently published RIBA Professional Service Contract 2020 makes clear that the architect/consultant is not responsible for compliance with the project programme, essentially saying that they won't be responsible if there is delay to that programme or prolongation. In addition, the RIBA PSC 2020 also includes an overriding duty of care, which help ensure there's no strict obligation on the consultant to comply with the programme. Other helpful mechanisms in the RIBA PSC 2020 include, as indicated in the slide, an entitlement to additional payment due to prolongation for causes outside the architect/consultant's control, which specifically include, as an example, where performance of the services is delayed, disrupted, or prolonged. The RIBA PSC 2020 does not deal specifically with extension of time, though, and that's another important point to always consider when negotiating an appointment. So moving on to the ACE Professional Service Contract 2017. This only requires the consultant to use reasonable endeavours to comply with the programme, which should mean that the consultant is not responsible for delays outside their control. In addition, the consultant is entitled to additional payment if it has to carry out additional work or suffers disruption in the performance of the services because of delay by the client or other reasons beyond the consultant's control. As indicated in the second point on the slide, there is a requirement on the consultant to notify the client of any delay. So even under the ACE, it is still important to make sure you manage change and notify the client as and when required. So moving on to a slightly less consultant-friendly standard form, how does the NEC4 PSC deal with prolongation? As those that are familiar with the NEC4 form will know, the NEC4 PSC includes detailed program requirements, including that the program is provided at the start of the project and regularly updated. So under an NEC form, it's even more important to manage prolongation on an ongoing basis. The NEC4 also includes a strict obligation to comply with the completion date, and if secondary option X7 applies, delay damages may be payable for failure to meet that completion date. This all underlines why under an NEC form it is really important to manage prolongation. As those familiar with the NEC forms will know, the only entitlement to additional payment and an extension of time under the NEC4 PSC is in accordance with the compensation event process. And by way of a starting point, there is no compensation event for general prolongation due to circumstances outside the consultant's control. However, there are a number of compensation events which may be relevant to prolongation, such as clause 60.13 as indicated in the slide, and 60.15 also indicated on the slide, which relate to failure by the client and third parties to comply with the accepted program. There is also a compensation event for prevention type events, as again indicated on this slide, although the threshold for this is relatively high, as the event must be something that an experienced contractor would not have judged could have occurred, and a prevention event would not cover prolongation that's caused by the client. This means that although some compensation events may have arisen after prolongation has occurred, it will be essential to identify which specific compensation events apply under an NEC contract. In addition, under an NEC contract, there are significant risks of letting prolongation build over a period of time. The NEC4 PSC requires early warning notices to be given if there is any delay and compensation events to be notified within 8 weeks. Failure to do so will mean that the compensation event may be time barred, or the consultant's entitlement to additional payment and an extension of time will be reduced. In addition, if a compensation event does arise, the impact of any delay is assessed by reference to the most recent accepted program. So if the program hasn't been updated, this will reduce the impact of the prolongation and the compensation event that arose. This all underlines the need for any delay to be proactively managed under the NEC4 PSC, and the program to be updated and notices given a global prolongation CE will be very difficult to succeed with. Now, for this final standard form, we'll look at the FIDIC Whitebook 2017, which does include an obligation to comply with the programme and the time for completion, but it does include an entitlement to an extension of time and additional payment due to third-party delay and variations, and also helpfully states that any change in the timing of the performance of the services will be a variation. As I said, this is a helpful position. So, the standard forms take a number of different approaches to prolongation. With NEC 4 PSC and equally the NEC 3 PSC, if that is used, in particularly needing to be managed very carefully. As those attending this webinar will be aware, in the current market, it is very rare for a consultant to be appointed under an unamended standard form, and bespoke forms of appointment are more often used. Often, bespoke forms will limit the entitlement to additional payment, to additional services, which are instructed by the client, and require that any additional payment is agreed in advance of the additional services being provided. Obviously, this would not be any assistance to a consultant if they were trying to bring a claim for additional costs due to prolongation at a later date. There may also be a right for the client to unilaterally adjust instalments payable following any delay in the services, and a strict obligation to comply with the programme with no entitlement to an extension of time. Indeed, we have seen some appointments recently which even go as far as stating that prolongation will not result in additional fee being payable. These positions should obviously be resisted insofar as possible. Going back to our friends ABC Consultants, after submitting their fee proposal, they were required to enter into a bespoke form of appointment, which included all of the points identified in the slide. This would mean that it would be very difficult for ABC to recover additional payment unless they can show that the delay was a result of additional services that were instructed by the client and that they had agreed an additional fee in advance of those services being provided. In addition, unless an updated programme was agreed which reflected the delay that caused the prolongation, ABC may well be liable for in breach of contract as a result of the delay. I suggested previously that perhaps to try and address the issue of prolongation, consultants should try and act more like a contractor, and that is particularly the case under a design and build appointment. Contractors will typically have an entitlement to loss of an expense following delay and to an extension of time under the building contract if specified events occur and delay the works, which are typically defined as relevant matters and relevant events under the JCT forms. Other than the NEC forms, it is rare for consultant appointments to include similar entitlements. Indeed, we have heard of a number of consultants being asked to assist contractor clients to recover loss and expense and claims for extension of time under the building contract, but then the contractor will refuse to agree that the consultant is entitled to any additional payment or to amend the programme. Under a design and build appointment, it is therefore particularly important that delays are managed proactively and prolongation is properly addressed. It is also sensible to consider alternative ways of structuring the fee following novation to the contractor, e.g. with a rolling monthly sum being payable during the construction phase, if at all possible, and an express right to adjust the fee following prolongation or following an extended construction period, also requested. The impact of value engineering requests, i.e. VE, should also be considered when working under a design and build appointment. If possible, express rights to additional payment and extension of time due to additional VE being required should be requested. This is important because value engineering can result in significant delay and rework, whereas applications for additional payment and time as a result of value engineering are often resisted by the contractor on the basis that they will see value engineering as design development and not additional services. Finally, when working for a design and build contractor, transparency in relation to the position under the building contract should be sought if possible, and consultants should consider offering to assist with any claims the consultant may have that are relevant to the design services, on the basis that the contractor may be more likely to agree that the consultant is entitled to an increase in the contract sum and an extension of time. Obviously, given the anecdotes I mentioned earlier, you need to tread very carefully there, but it is an approach that may assist the consultant's position.
Thanks, Andrew. So building on sort of the suggestion to think more like a contractor, act more like a contractor. As we said, the contractual approach tends to differ, and understanding how additional time and money works in contractors' contracts will assist in ensuring consultants can be equally protected should the project be delayed through no fault of their own. And as Andrew said, one of the drivers is liquidated damages, which means that the contractor is at financial risk if the completion date after the contractual completion date is after the contractual completion date. And on large projects, we know that LADs can run into tens of thousands of pounds per week. And because of this, construction contracts tend to have clear processes as to whether the contractor is entitled to an extension of time, and particularly so under the construction standard forms, the JCT and the NEC EEC. And while these also contain condition precedents on notification, contractors do tend to be more alive to potential delays to the programme and make appropriate notices if the cause falls under what is a relevant event. Now, of course, contractors do have greater control and knowledge of the progress of construction works to enable them to make timely notice. As such, even if your attendance on site is periodic or you are behind the scenes, inquiries should be made as to what the construction programme is, and so you can be aware of any delaying events to protect your position. You should also ensure you get a copy of the contractor and employer progress reports to have an idea as to whether any delaying events are happening or are foreseen. The entitlement that contractors have to loss and expense is also slightly different. It's connected to a relevant matter, and these are typically calculated using the contractual preliminary rates for the additional period on site, plus if any new additional costs arise. There will also be costs for head office overheads, which can be claimed based on actual cost or applying a percentage uplift to that. And there are three formulae that are used, either Emden, Hudson or Itchley. And although consultants may also suffer from lost overheads and profits, these formulas are seen not to be generally applicable to consultants, and we are actually not aware of any case law in which they have been used by consultants. And this may make sense, as typically consultant fees are based on either hourly rates or a percentage of the total construction costs, with those values deemed to include overheads and profits in its baseline. Therefore, if a consultant recovers an additional 10 hours based on the hourly rate, this is deemed to include the necessary profit allowance. As Andrew mentioned earlier, key industry guidance on delay and disruption on delays to works doesn't really reflect services. However, the advice given is useful for consultants to consider with regard to the presentation of a claim. So moving on, this is sort of some advice as to what to do with your arguments following prolongation. And ideally, you'll be aware when a period of prolongation is anticipated, and you can take steps in advance so that the position is addressed, at least in terms of establishing an entitlement to additional time or an adjustment to the period of time you're providing your services, acknowledging that the exact entitlement is unlikely to be known. For example, the project will overrun and will require additional site attendances, but the exact number cannot be known as at the date of the notice. So we consider the first step is to review the appointment to ascertain the process for making a claim which may arise from prolongation. And these are typically tied into clauses related to additional fees and time for completion of services. The information to ascertain is who to give notice to, the content required for the notice, the timing of the notice, and again including any condition precedent, and the evidence required to support. And in this regard, it's also good to understand ongoing duties with regard to a claim for additional time for prolongation and additional money. And this is whether regular updates on the period of prolongation is to be provided, whether the period of time is going up or down, updates on costs and likely expenditure, and when actually you can invoice for additional fees. As some appointments we have seen actually have invoicing for what is deemed additional fees at a different time to that of the main service fee. And by being proactive at this stage, consultants can also press for more information as to the management of the underlying construction contract to better understand the cause of prolongation and programme going forward. It's important because it may indicate, for example, whether the employer or the contractor considers that the professional team are responsible for the delay event. The second step on this side, the factual matrix, in reality should be done at the same time as understanding the contractual position. And the key elements of this appraisal includes what work stage or service is the prolongation impacting on. If the prolongation event is to one particular stage, can it be shown or predicted that it will have a knock-on effect to later stages? For example, the later stage cannot be started until the previous one has finished. Identification as to what services are being impacted is very important. There are three broad effects prolongation can have, as we earlier discussed. And the services that are to be provided over a longer period and increased quantity and or are additional services required due to prolongation should be identified. And as best practice, we would recommend that those services are listed and kept in a central repository so that key information can then be scheduled out against each, including, is it increased quantity or an additional new service? If it's an increased quantity, what was the basis of the fee in the appointment? So we can then extrapolate that out for the claim for the additional work. For the additional new service, does it fall under something that will be recoverable by the hourly rate if that was included in your appointment? It should also be identified what allowance was in the appointment for the original service, because some appointments provide for providing that service over a defined time or a number of instances, but others could be open-ended, which could restrict the entitlement to claim. The status of the performance against the appointment's allowance is also important, because if you have allowed for 15 meetings, for example, you need to know how many have actually taken place, as there may be some instances where the employer might say, well, they don't actually agree that you've attended that many meetings, and seek an adjustment to your claim by that mechanism. And consultants should also be allowed to request for additional services that arise due to the prolongation that the employer may seek to contend relate to the same services at no additional frequency. And also, as indicated on this slide, consultants should be proactive in their own understanding of the cause of prolongation. And this is in order to show, should it be needed, that the consultant is not responsible for the prolongation event. And again, while it's often the case that consultants may not be kept updated as to programme developments, particularly during the construction phase, and what the cause of delays are, consultants should take a step back and consider timings in their appointments for providing services, whether those dates have been met. If not, can the reason or reasons be identified? And do the reasons relate to performance issues on the part of the consultant? And having done the above, attention will inevitably then be drawn to the financial impact on the consultant of the prolongation. If claims are not made in time or on the correct footing, then a consultant can incur significant irrecoverable costs in continuing to provide services during prolongation. In particular, clear staff resources being diverted to providing the additional services prevent fee earning on other projects. In addition, a consultant can be in breach of contract and duty should they not continue to provide those services. To assess the financial impacts, as mentioned before, consideration should be given to the applicable services and how the original fee allowance was set out in the appointment. Often there is an overall fee with a monthly drawdown. However, this may not be sufficient to evidence the loss going forward if, for example, during the period of prolongation, not all services that would have made up that monthly figure have to be carried out. And so the best evidence is actual time records for the services carried out in the prolonged period, with the contractual hourly rates applied to them. As an example, because we've raised it before during this webinar, is ongoing site meetings. It should be easy to maintain records that staff member A attended 4 extra meetings, for example, and those meetings lasted 2 hours each. What can be harder to recover are incidentals arising out of that meeting if those incidentals were not initially separated out in the fee allowance. These incidentals, which would be additional because of the prolonged period, because you weren't expected to attend that additional meeting, may include travel costs and time, reading reports circulated in advance, and preparing minutes. However, such time should still be recorded, and if there is a potential issue, recorded separately rather than a block for a meeting. So rather than an entry that states staff member A spent 4 hours related to the December meeting, a better entry would be staff member A spent 1 hour travelling to and from the meeting, 30 minutes reviewing the pre-meeting reports, 2 hours at the meeting, and 30 minutes preparing the minutes. And this type of recording would also prevent against claims that what is being claimed as an additional fee caused by the prolongation includes something that is part of the basic fee. Going back to our case study, if the fee allowance included 2 meetings with the planning authorities, but in the prolonged period an additional meeting was necessary, then is this the same service but increased frequency? Will it depend on the cause of the meeting? If it is because of the planning authorities' delays and their failure to deal with the application properly, then yes, we would say that would be the same service having to be provided in an increased frequency, and so should be claimed. The description given in the record keeping should also go back to the prolongation event, and on the slide is an example that could be used if relevant. And this can also be applied where additional service is being asked because the client is taking advantage of the prolonged period. So, for example, additional work done on workstage E or whatever the workstage may be, following comments from the client after the design was fixed. Finally, as indicated on the side, for the financial point of view, the fallback is a claim for quantum merit if the records are lacking or there is an argument. And quantum merit is where the consultant is entitled to an additional fee, but the amount can't be ascertained. The amount of a quantum merit fee is a reasonable fee for the work carried out. And this, of course, carries risk. Firstly, in showing what work was carried out, and secondly, the level of the fee, because it's rarely at the level the consultant considers is due. And reliance on quantum merit, largely says that the consultant has lost control of its own internal record keeping and what it had to do in relation to its services. And then finally, in terms of arguments available, the entitlements that prolongation can have in relation to the provision and timetable providing the consultant's future services. Such future services should be identified and assessment made as to their impact. They may not be possible, but if the consultant has identified that there will be an impact which cannot yet be defined or estimated, then that is a sound starting position to then update as the works continue and make the client aware. That way, future claims, if dates are missed, can be avoided, and the actual impact of a prolongation event can be charted through the project. This baseline can then also be used for any new prolongation events that happen, although consultants should be aware that the more prolongation events that occur, the more difficult it will be to prove an entitlement if one or more events have potentially been caused or contributed to by the consultant. Often any entitlement to additional fees or adjustments to the programme for services contain condition precedents, and therefore following these practical tips should hopefully allow you to avoid falling into that trap. But even if they don't contain condition precedents, and so you don't have to make a timely notice, if you opt not to do so, then there is a risk that continuing to provide the service in a period of prolongation could be seen as a form of waiver over the right to claim additional fees. A further risk is that the consultant could be stopped, i.e. prevented, from raising a claim for additional fees in the future, or for using the prolongation event and impact on their services as a defence to any claim. Andrew.
Many thanks, James. I will now consider how to address prolongation contractually and provide some practical pointers which generally summarise a lot of the key points we've been discussing today. Now, the easiest and simplest way to address prolongation contractually is to include an express contractual entitlement to additional payment and to an extension of time if the services are prolonged or delayed due to circumstances outside your control. As indicated in one of the questions we've received today, it's not always easy to get that right into a contract though, and it's often something that clients will push back on, but it's still something that you should try and get in there if you can. You should also try to avoid strict obligations to comply with the programme by making clear that those obligations are essentially qualified by your duty of care, and watch out for a unilateral right for the client to update the programme throughout the course of the project, and try and include a mechanism for either the consultant to update the programme if there is delay, or for updates to be agreed. In addition, any assumptions in relation to the anticipated duration of the services or any stages which the services will be performed during and which form the basis of the fee should be included in the final appointment, with a specific trigger for additional payment to be made if they are exceeded. Going back to our case study and ABC Consultants, the fact that they had stated in their fee proposal that they would expect additional fees if the services were prolonged or the time periods were exceeded would often provide very limited support, because at a later stage they would have been provided with a written appointment by the client, which, as I said, was a bespoke form, and that would have included an entire agreement clause that made it very difficult for ABC to rely on their fee proposal unless that statement was somewhere incorporated into the appointment itself. So unless you do so, it's very difficult to enforce any qualifications you might have included in your fee proposal in relation to prolongation and timescales. Finally, as James has been mentioning during the course of the webinar, there are other ways you can try and limit your fee to reduce the risk of prolongation by trying to set some other parameters, and these may be more acceptable to a client than a general right to additional payment just because the services are prolonged due to circumstances outside your control. For example, by capping the number of meetings with an additional fee being payable if they are exceeded, by considering how you charge for the construction phase, whether or not you're being novated, such that in an ideal world, either you're entitled to a monthly fee depending on how long the construction phase continues, or at least to make clear that if the construction phase exceeds the anticipated duration, you would be entitled to an additional fee. So, how practically can prolongation be managed and addressed, and how should it be managed and addressed? Firstly, it is very important not to leave the contract in the drawer and to try and manage every contract proactively. As I mentioned previously, try and think like a contractor would in relation to any delay or prolongation, and address it as soon as you can and discuss it with the client. This includes monitoring and managing delay during a project on an ongoing basis, and notifying delays and their impact on the services as and when they occur. The programme should also be updated to reflect the delays, and the client notified if additional services are instructed, with additional fee and programme adjustments agreed if possible. The longer that prolongation builds up during the course of a project, the more difficult it will be for a consultant to recover additional fee and to be entitled to an extension of time, and the more difficult conversation you'll have to have with your client. So where possible, it's important to try and nip any prolongation in the bud and discuss it with the client as soon as possible. Just looking at the time, I'm afraid that we will not have time to deal with any questions raised during the course of the webinar, and we have had a few. As we mentioned at the start of the webinar, we will circulate questions and the answers to all attendees. Please also feel free to email me or James directly if you wish. Our contact details will be on the very last slide of this prolongation of this webinar. Just before we sign up, I just wanted to take a moment to remind everyone of the upcoming knowledge sessions as part of Beale & Co.'s Construction Winter Webinar Series. Starting with the previous webinars we've held, on the 25th of November, Beale & Co. partner James Hutchinson led the session called Software as a Service, Consultants as Technology Providers, and the Legal Ramifications. In addition, recently, Will Buckby and Ian Masser considered the very topical issues of external wall fire safety and the EWS1 form. These sessions were recorded, as this one has been, and are available to download and watch at your leisure on our website. If you missed these sessions and would like to watch them, do contact us and we can send you the details. Now, looking into 2021, as indicated in the slide, Beale & Co. partners Joanna Lewis, Nathan Rodell, and Michael Salau will be delivering a session looking at where will the golden thread lead, in particular the draft building safety bill. And last but certainly not least, on the 20th of January 2021, Will Buckby will be giving a talk with Associate Robert Reed discussing the hardening contractual and insurance markets for construction professionals in a session titled Contractual Considerations in 2021, A New Landscape. If you have not registered for these sessions or require any of the recordings, please send an email to the address indicated on the slide, i.e. webinars@bealeandco.com or marketing@bealeandco.com. As discussed, here are James and my contact details if you have any specific queries. As mentioned, we will circulate the slides and a recording of the webinar shortly and responses to the questions. We will also be publishing, as a firm, an article on prolongation shortly, and we will circulate that to attendees as well. It remains for me to say thank you very much for joining me and James this afternoon. Stay safe, enjoy the rest of your day, and have a very good Christmas. Thank you and goodbye.
Thanks very much, everyone.